Good morning, good afternoon, or good evening, depending on where you are in the world, and welcome to Finnegan's webcast, Post-Grant Amendments. I'm Anthony Tridico, and I'll be your moderator today. It's my pleasure to welcome our presenters, Hazel Ford from our London office, and Tim May from Washington, D.C. Before I turn things over to our presenters, I invite everyone to participate by submitting questions. This is an interactive webinar, and we'll try to answer as many questions as we can at the end of the presentation. Just click on the red Q&A button at the lower center of the webcast interface and type your question into the Q&A window and click Submit. The questions will be answered, hopefully, as many as we can, as I said, at the end of the presentation. You may enlarge the slide window at any time by clicking on the green Enlarge Window button on the top right side of the slide window. The slides will advance automatically throughout the event. If you're experiencing any technical difficulties, please click on the yellow Webcast Help Guide button in the lower center of the webcast interface. Before we start, a quick shameless plug for our upcoming attractions. We hope you can join us on May 30th for our next program in the series, Strategic Use of Post-Grant Challenges. To register for this webinar, please click on the webcast link in the resource list. Now, grab your popcorn, and I'll turn it over to Hazel and Tim to begin our presentation, Post-Grant Amendments. Welcome. The floor is yours.
Thank you, Anthony, and hello, everyone. Before Hazel and I begin, I wanted to start with an overview slide of what we plan to cover in today's webcast. First, we'll begin with setting the stage in terms of what types of amendments or why we might want to amend our claims using some of the procedures or tools that we'll be covering. But then as we turn to the substance of today's presentation, Hazel and I plan to go back and forth. We will try to compare the tools and options available to you in Europe as compared to those available to you in the U.S. And we're also going to try to break this out into the different stages you may find yourself in when dealing with potential amendments or fixes or corrections of your patents. So we're going to begin, as you see here in the overview slide, with the tools that would be available to you at the Patent Office. So Hazel will begin with addressing those available at the EPO or other national patent offices in Europe, and I'll compare those to those available at the U.S. Patent and Trademark Office or the USPTO. I will then kind of turn towards other types of contentious proceedings that you may find yourself within. With respect to the EPO oppositions, therefore, of course. And at the USPTO, as I'm sure many of you are familiar with, we have now the acronyms are IPRs and PGRs that we'll be referring to. Those, as many of you know, stand for inter-party review proceedings, and PGRs meaning post-grant review proceedings. We will then turn towards the types of amendments that we may be able to make or not make in litigation. Again, comparing those in Europe versus those in the U.S. And then finally kind of wrap up with some strategies on how, when, and where you might want to make your amendments and some of the interplay that you may experience if you're involved in one of these proceedings when you have a parallel litigation, for example, or a parallel contentious proceeding, for example, at the USPTO. So let's begin with, again, just to set the stage here for why we might want to amend. And the driver here is often a business reason or a business situation where, for example, perhaps the business is aware of a competitor infringing or copying our technology. We believe that there may be a potential patent infringement dispute, and we might be heading towards litigation. Or perhaps, the business wants to monetize our IP portfolio and may be interested in engaging in a licensing campaign. Perhaps the business wants to sell a portion of our patent portfolio. But all these types of situations typically lead to a due diligence investigation of your IP or of your patent portfolio where we're investigating the ability of our patents to achieve these goals that have been outlined by the business. It's usually through this type of a due diligence investigation where we're taking a deeper dive or a closer look at our patents, where we might uncover certain issues that we may want to fix or correct in our patents. We may determine this through our due diligence investigation, for instance, that our claims are overly broad in view of some new prior art that we've become aware of. Perhaps we feel that now having a better understanding of what our competitors are doing, that we could have better claims that are more targeted to read literally on what that competitor is doing in the marketplace. And there could be other issues, of course, that we might uncover that we might need to fix just to strengthen our scope of protection. And so the goal here today, again, is to try to outline for you, those options that would be available for making these types of changes or fixes or corrections in Europe versus in the U.S. And with that, I'm going to turn it over to Hazel, who's going to start us off with some changes in Europe. Hazel?
Thanks, Tim. So I'm going to start off by looking at the options that are available if you want or you need to amend your European patent when you're not in contentious proceedings over that patent. So when you just want to make an amendment voluntarily and ex parte. Just as a quick reminder, the European Patent Office will grant you a patent that covers many different countries. There are 38 EPO member states, but after it's been granted by the EPO, it becomes a separate patent in each of those states, and it needs to be maintained and enforced separately in each state. So the patent can be dropped in some states and maintained in others. It can be litigated in individual states and before different national courts around Europe, and those courts are free to take their own independent decisions as to whether the patent in their country is valid and whether it's infringed. And it's not unusual around Europe to get different decisions on the same patent in different countries. Although the EPO isn't responsible for the patent post-grant, you do still have choices if you need to amend your European patent after it's granted. If you want the amendment to apply across all of Europe, you can amend it centrally at the EPO, with the amendment applying in all of the EPO countries. If you only want an amendment in some of the European countries, then you might want to consider filing a national amendment just with the National Patent Office in an individual country. So at the EPO, there is a procedure to allow you to make an ex parte post-grant amendment, and this is called the central limitation procedure. It's a remarkably simple procedure. It's a patentee-friendly procedure as well. Basically, the patentee can go to the EPO and request a post-grant amendment of their European patent and pay a fee to the EPO for them to do that. They can file this request for amendment at any time after the patent's been granted, even after the patent has expired, with the one exception that this procedure can't be used at the same time as an ongoing opposition or appeal at the EPO. And I'll talk a bit more about amendments in oppositions later on in this webinar. If you file a request for central limitation with the EPO, you don't have to explain why you're doing it. You don't have to explain why you're making the amendment. If you're making an amendment because you found some new prior art, that means you think there may be a problem with your original claims, you don't have to explain that to the EPO. You don't have to give them a copy of the prior art. You don't have to tell the EPO if there are any other problems with the granted claims that they're not aware of. You might want to consider explaining why they should allow the amendment, but that explanation doesn't need to include any discussion of substantive issues or the reasons for the amendment itself. And that's because the EPO doesn't carry out a substantive examination of your amended claims. The EPO accepts that if it found the granted claims to be patentable when it examined your application, then a more limited version of those claims must also still be patentable. The examiner who looks at your amendment in the central limitation procedure won't consider the prior art at all. The procedure doesn't reopen examination of the application. The examiner is only allowed to look at specific formal aspects of the claims, and it's those that you might want to explain when you file the amendment. The first requirement is that the claims as amended need to be clear. They also need to meet the requirements of Article 123 EPC, so they mustn't include any added subject matter compared to the application that was originally filed, and they mustn't broaden the scope of the granted claims to cover anything that wasn't originally covered by the patent as granted. You can't expand the scope of your protection post-grant in Europe at all. As well as causing no broadening of the claims, because this is a central limitation procedure, the amendment actually needs to limit or narrow the scope of your patent. Some subject matter has to be removed from the overall scope of the claims as a result of your amendment. If you have an amendment that improves the clarity of the claims without limiting the scope, then that is probably not going to be allowed by the EPO. Amendments that aren't limiting on the scope will usually only be allowed if they are the direct result of a limiting amendment that's being made at the same time. So, for example, if an independent claim is split into two claims to exclude part of its subject matter, then under those circumstances you may be able to add additional claims to help you achieve that, and the changes in the dependent claims that directly reflect that change may also be allowed. But just adding a new dependent claim to your existing granted claims, for example, to specifically refer to a preferred embodiment, is something that you're unlikely to be allowed to do under these proceedings, because that kind of amendment doesn't change the overall scope of protection from your patent. Similarly, you can't use the central limitation procedure to tidy up other aspects of your claims unless you can justify that those extra changes are directly caused by a limiting amendment that you're making at the same time. If the examiner is not satisfied that you meet these requirements, then you may get a round of written examination as part of the central limitation procedure, or you may even be summoned to oral proceedings at the EPO. If your application for an amendment is refused by the examiner because your amendment doesn't meet these formal requirements, then all is not lost. You can just file another application for amendment, perhaps with a slightly different amendment that does deal with the problems that the examiner has identified. You pay the fee again, and it goes back into the procedure, and the examiner will look at it. If your application for amendment is accepted, then you need to complete various formal requirements. You'll need to file translated versions of the amendments at the EPO and maybe in some other European countries, but your amendment will then have effect in all the states where the patent exists, and the change has effect ab initio, as if the patent was originally granted with the amended claims. So that's what you can do at the EPO. What happens if you only want to amend your patent in some countries? It used to be the case that it was very difficult to amend your patent post-grant in Europe, and most EPO countries used to have essentially no practical provisions to allow you to make a post-grant amendment. But since the EPO introduced its central limitation procedure, many EPO countries have themselves introduced new procedures having a similar nature that let you make national amendments in those countries. Even with these new procedures that have been introduced, there is still some inconsistency across different European countries. So France is one example of a country where amendment was generally not possible after grant until a few years ago. There is now a procedure in France that allows central limitation of a French patent post-grant, and the procedure in France is now actually very similar to the central limitation procedure at the EPO. For example, that in France there's no requirement to justify or explain why you're making amendments. Germany and the UK did both allow post-grant amendments before the EPO introduced its central limitation procedure, and they continue to do that now. But in Germany and the UK, the specific procedure is different to that in France or at the EPO. For example, they will require the patentee to explain the reasons for the amendments that are being made. Because you have these inconsistencies between the different offices, and because the EPO's procedure is so simple, in many cases it is going to be easier to make the amendments centrally at the EPO. But the disadvantage of doing this is, of course, that you're now going to have to make the amendment across all states, rather than just making individual amendments in separate countries. I'm going to hand back to Tim now, and he can tell you about the equivalent tools at the USPTO.
Thank you, Hazel. Before I begin and go through the tools and options available at the USPTO, I thought it'd be useful to set the stage a little bit more from a U.S. perspective. If we're considering litigating or enforcing our patent, given the current climate, we can almost predict what a challenger or accused infringer may do. It's almost a sure bet. It's a good bet that accused infringer will likely challenge our patent that we are trying to enforce or litigate against that competitor by challenging the validity of our patent at the Patent Trial and Appeal Board, or the PTAB, that adheres these IPR proceedings or PGR proceedings that I was referring to before. As many of you know, if you are involved in one of these proceedings, if your patent is subject to one of these proceedings, it's a daunting scenario. Here, you can face a likelihood, statistically speaking, that the PTAB will invalidate the claims of the challenge claims of your patents 75% of the time. That's a high number. You can also appreciate that you will also have a limited ability to amend your claims in one of these proceedings. While there is an option, as we'll talk about later, that is available to do so and to try to move to amend your claims, you have a limited ability to actually make those types of amendments in one of these proceedings before the PTAB. While you could try to amend your claims or fix your claims by filing a reissue or a reexam, again, as we'll be talking about shortly, the reality is that those can take time, and that the USPTO or the PTAB may also stay or put on hold that reissue proceeding, application or reexamination proceeding. So one thing to kind of keep in mind, given just the current climate of your patent likely being hauling before into the PTAB and one of these IPR or PGR proceedings, is to be proactive in advance and consider your options for amending or strengthening your claims before you were to enforce or before you were to litigate. And if you do that, there's several advantages in doing so. First, not only will you end up with potentially stronger claims that are better distinguished the prior art, that also are stronger for purposes of infringement because they more directly read upon the accused infringer and their activities. But through one of these proceedings, you will also submit new prior art to the Patent Office, and so your stronger claims will also be blessed or confirmed over this new prior art. So going through this process, you can end up with a much stronger patent, battle-proofed or bulletproof, if you will, much better prepared to withstand the attack that we're likely to expect in one of these IPR or PGR proceedings. So with that as a bit of a background, and as we're trying to navigate the types of changes or amendments that we would want to make to our patents, there's a lot of issues to balance. It's often a delicate balance that we have to take, and navigating this path, can be difficult because on one hand we want to perhaps broaden our claims to cover our competitor activity, but on the other hand we need to be concerned about amending our claims to avoid the prior art. We may also need to amend our claims or ensure we have limitations that are consistent with the earlier prosecution. Perhaps there were amendments that were made during the early prosecution that distinguish the prior that was cited by the examiner. We need to be consistent with that prosecution history. We also need to, of course, be consistent with the support and the language in our original application. On the other hand, we might not want to add many amendments or be careful about the language that we do add to our claims to avoid the issues that occur with prosecution history estoppel. We also may need to take into account some of the changes in the law. I'm sure many of you have been following, for example, the changes with respect to patent-eligible subject matter, functional limitations in our claims as well. We've had lots of developments in our case law that we may also want to take into account when we are trying to navigate this difficult path and determining what types of amendments we can make that will be useful and effective during our enforcement or litigation strategy. So with that said, I want to now turn towards the types of tools that are available at the USPTO for correcting or amending your patents. I've listed the four here: certificates of correction, reissues, ex parte reexaminations, and supplemental examinations. I'm going to spend most of my time on reissues and reexaminations. But these four, they can differ in terms of the types of changes that you can make, and also the purposes for why you might want to use them to make changes to your patents. I've listed here just for your reference the sections of our statute that govern these different types of tools that are available for correcting your patents. Let me just begin then with certificates of correction. As perhaps the name implies, these are for relatively minor mistakes. And there are two types of mistakes that can be made or corrected by a certificate of correction. First is mistakes made by the USPTO. So, for example, perhaps there was a mistake that the office made in the printing of the issued patent that is not consistent with the earlier prosecution, or perhaps it's an innocent mistake by the applicant or the patent owner. And the types of mistakes that can be corrected here are those that are of clerical or typographical nature or of minor character. And in showing that the types of mistakes that can be corrected by certificates of correction, we're often referring to the prosecution history to show that these were more of the minor type of mistakes that can be corrected through certificates of correction. One take-home point that's worth noting here is to make sure you have a part of your regular procedures, as we do here for all of our prosecution matters that we handle, that we'll do a proofreading process. We'll proofread the published patent just to see if there are mistakes in the granted claims or perhaps on the face of the patent that we would want to correct in advance. As we'll be talking about in a few upcoming slides, correcting these types of mistakes earlier on as part of just your regular procedures is often very prudent because if we don't do it until later, perhaps we can run into issues, and I'll also explain more. And the cost and the time and effort involved for these types of corrections are relatively minor. You can see the governmental fee that's associated here, and we usually incorporate the work involved into our post-allowance procedures to identify and then proactively attend to these types of corrections. More substantively are reissue applications, or the types of errors that can be corrected through reissue. And according to our reissue statute, you can correct errors that would render the patent partly or wholly inoperative or invalid. And this is a rather broad type of errors that can be corrected through reissue. And you see, them listed here. They're not simply errors in the claims. That might be one of the more common types of errors that are corrected through reissue, where our claims are perhaps too broad or too narrow. But you can also correct defects that may be identified in the specification or perhaps in the drawings. Maybe there's a missing priority claim, or even, as you see listed here, inventorship issues. I will point out that some of these types of errors that can be corrected through reissue can overlap with some of the other tools that we'll be talking about as well. Again, I'll be talking about reexaminations, and we can also make changes to our claims through reexamination. You can also, for example, correct priority claims in certain situations through a certificate of correction, for instance. So just keep in mind these are not necessarily, there is an overlap between the types of edits or changes that can be made through these different types of tools. Now, one issue that comes up with reissue applications is this concept of whether the claim amendments that we may be proposing, whether they are broadening claim amendments or narrowing claim amendments. And this, whether the amendments that we are trying to make through reissue is a broadening amendment or a narrowing amendment, does impact our ability to pursue these types of amendments in a reissue application. And when we're talking about a broadening amendment, we're talking about an amendment that can broaden the claim in any possible way. And so, as you can see here with the different Venn diagrams, clearly on the top left, that is a broadening amendment because we've removed limitation C. But for purposes of the reissue statute, the types of amendments that are illustrated in the top right and the bottom left, those are also broadening amendments. Even though we, for example, in the top right, added the limitation D to the claim, because we removed limitation B, the claim is still broadened because it was broadened by removing limitation B, again, even though it was narrowed by adding limitation D. So when we're talking about a narrowing amendment, we're talking about where all of the features of the original claims are still being pursued in the reissue, but we are now adding an additional limitation. And that comes up because if we are pursuing a broadening reissue, we need to do that within 2 years of the grant of the original patent. Take-home point here again is to then docket in your system this 2-year date. Preferably, you want to be docketing a date several months in advance so that if you do believe that this is an important patent that you may want to broaden given activity in the marketplace or other issues, that you have time to prepare an appropriate reissue application to seek those broadened claims. And if you do file a broadened reissue application within the 2-year time frame, you will also have the ability, as illustrated here in the boxes towards the bottom of this slide, the ability to also pursue other broadened claims after the 2-year date. But if you are going to pursue broadened claims, you need to file a broadening reissue application within that 2-year time frame. Otherwise, you will have lost the right to do so. I wanted to list here that the types of amendments that could be pursued through a reissue strategy. And we'll be weaving some of these types of amendments in when we talk about some of the other parallel proceedings that we might be faced with. But for example, if we decide to narrow our claims through reissue, certainly we do so if we're aware of new prior art that may have come up in our own pre-diligence investigation, but maybe we're aware of prior art that has been identified to us by a competitor, perhaps through an IPR proceeding. And we want to now try to pursue an option for amending our claims to distinguish that prior art. We can do that through a reissue. We can also simply add new dependent claims. Perhaps we want to maintain our current original independent claims, and we don't want to impact our rights that we have with respect to the competitor infringing those broader independent claims, but we want to add more backup claims in the form of dependent claims as a hedge or a safeguard in case we're involved in any type of validity attack. That might be certainly an option or a strategy for reissue. Another strategy for issue may be to provoke interference. Perhaps there's a competitor patent that has claims that we believe that go to subject matter that we invented first. We can use the reissue to insert or add claims that copy the competitor's claims and provoke an interference proceeding. And of course, as I was mentioning before, we can also pursue broader claims that we felt that we are entitled to, and that was the error that we are seeking to correct through reissue. Because perhaps through our due diligence investigation, we've identified other activity that the competitor is doing, but we need broader claims to capture that. And if our claims have support for those types of broader claims, we can do so if we do so again within 2 years. Now, a big issue that comes up if we were to file a broadening reissue application is the recapture rule. And having litigated a reissue patent in the past that was a broadening reissue, and where the recapture rule was central to the case, I can tell you it's a very complex rule. But essentially what the rule says is that a patent owner seeking a reissue, trying to broaden their claims, can't recapture subject matter that was surrendered during prosecution. When you've made amendments to your claims during the original prosecution to distinguish the prior art, the recapture rule addresses your ability to try to rebroaden your claims and to recapture subject matter that you previously surrendered during that original prosecution. I want to turn now towards reexaminations. And as many of you know, you can file an ex parte reexamination to challenge a competitor patent. But many of you may not know that you as a patent owner can also file an ex parte reexamination on your own patent. And so this can also be a tool that a patent owner may choose to amend their claims in their issued patent through the reexamination procedure. Now, the reexamination, as I'll address in a subsequent slide, it does differ from a reissue by the types of grounds or that can be corrected. So while reissue is any of the errors that I was describing before, reexaminations are limited to grounds based upon prior art in the form of patents or printed publications. And making changes to our claims given substantial new questions of patentability, or SNQ as you see referred to here, relating to that type of prior art. But what I want to bring to your attention here is the timing that has changed for ex parte reexaminations. Ex parte reexaminations, as you may know, go to not to the regular examiner that was handling the original patent, but it goes to a specialized group of examiners called the Central Reexamination Unit. And the Central Reexamination Unit has become less busy over recent years with the introduction of these new AIA proceedings, the IPRs and PGRs. So as you can see from this table, which comes from the Patent Office's own data, it shows the number of ex parte reexamination requests that have been filed over the last 7-8 years. And as you can see, there has been a significant drop-off since these new AIA trials and tools have been become available, IPRs and PGRs. You can see the spike there in September of 2012. That also correlates to the fee increase that the U.S. Patent Office made for ex parte reexaminations. But as you can see, since then, there's been a significant drop-off in the number of reexaminations that have been filed. What I kind of wanted to bring to your attention as a result of that is the time to get an examination of your ex parte reexamination has dropped. It's now between 4 to 5 months that you can expect from the time you file your request for reexamination to when you will get a first office action. So you can have potentially a very quick proceeding through reexamination to improve your or battle-proof your patent through a reexamination. Here's a comparison slide of the reissue procedure applications, reexaminations, and supplemental examinations, which I mentioned before. Again, the big differences that I wanted to point out here are in terms of the grounds between the two. So for a reissue, it can be any error in the patent that, as I mentioned before, that renders the patent wholly or partially inoperative or invalid. While for ex parte reexaminations, it's limited to grounds based upon prior art in the form of patents or printed publications, and making amendments to distinguish that prior art that you are identifying in your reexamination request. Supplemental examinations, I'll be very brief on this, but it's a procedure or tool available to really cleanse the potential inequitable conduct allegations by submitting perhaps new prior art that the applicant or the patent owner was aware of during prosecution, but for whatever reason was not disclosed. And you can submit a request for supplemental examination, and if the Patent Office determines that the prior art that you're submitting does raise a substantial new question of patentability, then you enter into a reexamination-like proceeding. And if you can survive that supplemental reexamination proceeding, then you can rid yourself of the inequitable conduct allegations. With respect to the other differences between reissues and ex parte reexamination, what I wanted to mention here is how that procedure plays out during the examination. For a reissue application, it's essentially like a prosecution of your regular patent application, where you can file RCEs, requests for continued examination. You can do extensions of time, generally speaking. While for an ex parte reexamination, you essentially only have 2 office actions. You don't have the ability to file continuations, for instance. So if you're still losing when you get the final rejection from the examiner in ex parte reexamination, your choices are to either abandon or appeal. And you can see the difference in the government fees, as well as the relative timing that I listed here, based upon the USPTO's published statistics, as well as some information from our own experiences for when you can expect a first office action. With that, in the interest of time, I'm going to turn it over to Hazel for addressing further EPO procedures for amendments in oppositions and appeals.
Thanks, Tim. So we're going to move on now to looking at what you do if you're in contentious proceedings. So, for example, when someone has formally alleged that your patent is invalid. And we're going to start off by looking at oppositions at the EPO. An opposition is a post-grant attack on the validity of your patent, and it's something that's handled centrally by the EPO. When the EPO makes a decision in an opposition case, that decision applies automatically across all the EPO states where the patent exists. Under the EPO system, the patentee doesn't have an automatic right to make an amendment to the patent during an EPO opposition, and all amendments that are filed during EPO oppositions are at the discretion of the opposition division or the Board of Appeal. But in practice, amendment is a completely routine part of EPO opposition practice. If you look at the statistics on this slide, which is statistics from the EPO about their oppositions, you'll see that last year in 42% of the opposition cases where the EPO issued a decision, that decision was to maintain the patent in an amended form. So it's common for amendments to be considered as part of these opposition proceedings. The normal approach in an opposition is that the patentee will identify the claims that it wants to have maintained, and that's known as the main request. It's normally the claims as granted, but sometimes that will already be an amended version of the original claims that's been filed as part of the opposition procedure. As well as that preferred main request, it's common in EPO oppositions to have one or more auxiliary requests filed as fallback positions. And these are formally submitted in writing as part of the opposition procedure. And the idea is that if the main request is found to be invalid, then the proceedings will continue to go through the auxiliary requests in turn. The total number of auxiliary requests in an opposition case does vary considerably. The opposition division obviously has discretion as to whether requests are entered, and so there does need to be some consideration of how many requests the division in each case is likely to be willing to look at, and that's quite a subjective issue in each case. One of the more extreme examples that I've come across is the decision T280 of 11 that's mentioned on this slide, where the initial written submissions on appeal included some auxiliary requests. Those were then replaced during the written procedure with 227 new auxiliary requests. A few days before the hearing, the patentee then added 454 more auxiliary requests, and then at the hearing, when it appeared that these requests weren't going to be successful, they attempted to file 4 more auxiliary requests actually during the oral proceedings. And at that stage, the Board of Appeal refused to consider any more new requests, and the patent was revoked. This is obviously an extreme example, but it does illustrate a more general point that the earlier you file an amendment during EPO opposition and appeal proceedings, the more likely it is that that amendment will be at least entered into the proceedings, and it will then be considered as part of those proceedings. As you move through the different stages of the opposition procedure, you have an increasing risk that the opposition division won't consider your amendment anymore. So you really do want to file your amendments as early as you can. On appeal, things are usually even stricter. Based on the latest case law, you can't even guarantee that a new request that is filed with your appeal will be taken into consideration if it's a request that wasn't entered into the proceedings at the opposition stage. The types of factors that the EPO will consider when looking at amendments and requests and whether to take them into account, the most important is probably the prima facie allowability of the amended claims. If the amendment clearly deals with an issue that has arisen as part of the proceedings, and so it's clear that that amendment would help to move the case forward, then it's quite likely that that amendment will be admitted into the proceedings. The EPO will also consider other factors. It'll consider things like procedural expediency and whether there's been an abuse of procedure. Opponents will commonly object to amendments and say that they could have been filed earlier in the proceedings. The complexity of the amendments will also be taken into account, and that's because the opponent has to be given a chance to review and reply to any amendments as part of the procedure. In general, simpler amendments like straightforward deletions or combination of claims are more likely to be acceptable later in the procedure. than more complex amendments that, for example, come from the description of the application. Unlike amendments that are filed in central limitation, if you make amendments during an EPO opposition, they are going to be fully examined by the EPO as part of the opposition proceedings. They will be subject to a full analysis of patentability, and the opponent can raise all the attacks against the amended claims that were originally available against the granted patent. So novelty, inventive step, enablement, and so on can all be raised against the amended claims. In addition, there are some further attacks that become available to the opponent as soon as an amendment is filed in opposition. Clarity isn't a ground that can be raised against the claims as granted, but as soon as the claims have been amended in opposition, it can then be raised against the amended claims. Like with the central limitation procedures, the amendment has to have formal basis, but it must also not extend the scope of the patent beyond its originally granted scope. And then finally, any amendments that are made during an opposition have to be justified under a ground of opposition. This means that purely voluntary amendments may not be allowed in opposition proceedings. The patentee may be asked to explain how an amendment is justified as restoring novelty or inventive step, and so on. This means that, like amendments that are made in the central limitation procedure, it may not be possible to make amendments during an EPO opposition if they only improve clarity or if they only add a new dependent claim without changing the scope of an independent claim at the same time. So this means that there are some limits to the type of amendments that you can make during opposition. Then we move on to litigation rather than opposition. As I've already mentioned, a European patent granted by the EPO is enforced nationally, and the national courts will look at infringement, and they will commonly also look at the validity of the patent in that country. As I said earlier, it used to be the case that most European countries didn't readily allow amendments to be made in those countries post-grant. But since 2007, the EPO has set out some requirements to make sure that amendment is possible, at least in the situation where a European patent has its validity attacked in a national court or a national office. So the EPO requires that if only part of the claims is found invalid, then the patent is revoked only in that part, and the patentee should have the right to make limiting amendments to the claims of the patent as part of the national proceedings that relate to validity. The idea here is supposed to be to harmonise the approaches of the national courts around Europe, but as tends to be the case, the details of how this is implemented in each country is different, meaning that the actual amendment may not be available in all circumstances. I'm going to take the UK as an example. In the UK, during litigation, all amendments are at the discretion of the court. The patentee needs to justify why the amendment should be allowed, and a major factor when considering amendments in the UK courts is whether the patentee has delayed making the amendment. If the patentee knew that the amendment was needed or should have known that the amendment was needed, then they may not be allowed to make the amendment. So as an example, if you are the patentee and you start litigation in the UK, and the infringer can show that you were already aware of a key piece of prior art before you started those proceedings, then that might be enough to prevent you from being able to amend the patent during the litigation to distinguish over that prior art. If you knew that there was a potential problem there, then you should have amended the patent before you started the litigation. The UK courts are supposed to take into account the principles applied by the EPO in EPO opposition, but because the EPO opposition divisions and Board of Appeal have quite a lot of discretion as to whether they enter amendments or not, there's no real clear path or rule for the UK courts to follow. In general, the approach in the UK courts can appear stricter than the approach that you would have in an EPO opposition. A recent example of this was seen in the litigation between Warner-Lambert and various generics companies. In this case, the first instance court found that one of the claims was invalid for insufficiency. This attack was made late on in the proceedings, and when the patent was revoked on this basis, the patentee then applied to make an amendment to exclude the subject matter that had been found invalid. The court refused the application to amend. They said that the patentee should have indicated before the trial that they wanted to make the amendment. Unless the patentee could show that there was a good reason why they didn't make the amendment before the trial, then it would be an abuse of procedure, and so the amendment wasn't considered. That decision not to consider the amendment in this case was upheld on appeal, and this case is currently considered by the UK Supreme Court, and we're hoping for a decision on that soon. So hopefully we will find out whether this strict approach was correct. So in Europe, you do have the option to make amendments to your patent, both in opposition and in litigation, but in all of those cases there are constraints as to when you can do it. What happens if you try and combine some of these things together? I've already mentioned, so I'll go through this quickly, the EPO doesn't let you have parallel limitation and opposition proceedings. Essentially, if the case is already with an opposition division or a board of appeal, then that opposition or board of appeal will also consider any request for amendment. It can't be handled as a central limitation at the same time. In European courts, it's a little bit more complicated. In France or Germany, if you have a request for amendment that is filed when there is ongoing litigation, the request for amendment can continue to be processed, and you may find that the litigation is actually stayed until the Patent Office has decided on the request for amendment. In the UK, if there's a request for amendment made nationally, then that will normally get merged into the UK infringement or validity proceedings so that the same court deals with both of them. If you have UK litigation when a central limitation request is filed at the EPO, then the UK court might stay its proceedings, or it might require you to make the same amendment in the UK. And one example of this came up in the Samsung and Apple litigation. What happened in this case was that Samsung had tried to file amendments before the first instance trial in the UK, but they'd not been allowed to make those amendments, and the patents were ultimately revoked. After they'd filed their appeal, they then went through the EPO central limitation procedure to make a different amendment to the case that would apply in the UK. Apple objected to this. They said that this was an abusive procedure because if the same amendment had been filed at that stage of the UK proceedings, it would have been rejected. The UK court agreed that the amendment probably wouldn't have been allowed in the UK proceedings, but it said that that didn't mean it was an abusive procedure and that there was nothing that the court could do because the central amendment procedure, the central limitation procedure at the EPO, is a legitimate way of making amendments that cover the UK patent. So Samsung were able to get consideration of their amendment by going via the EPO rather than trying to amend in the UK. So in conclusion for Europe, there are options to amend your patent ex parte as part of contentious proceedings. What's the best approach to take in practice? It's obviously going to depend on your specific circumstances. In terms of where to amend, amendment at the EPO is often easier than trying to amend in the equivalent national offices because it avoids any inconsistencies between the different national approaches, but it does mean that you're going to end up having to have the same limitation across Europe. Wherever you do make the amendment, it is always going to be better to file the amendment as early as possible. Amendment in contentious procedures allows you the possibility of making a conditional request or an auxiliary request where you only have to actually amend if it's found that your original claim was invalid. But obviously you have a greater risk that your amendment might not be allowed than you would if you made an ex parte amendment. Whatever your suggestion, my recommendation from Europe would be to plan ahead and consider at all stages whether you are going to need an amendment, and if so, when the best time would be to make it. I'm going to hand back to Tim now to hear about the US.
Thanks, Hazel. Let me try to be brief given the time that we have. So I'm going to first address the ability to amend or correct your patents in either an IPR or PGR proceeding, as well as in litigation. The bottom line for both is you have very limited ability to amend your claims at either stage. If you're involved in an IPR or PGR proceeding, as a patent owner, you do have a right to file a motion to amend your claims. But it has been very difficult to have those motions granted and to have your claims amended. Prior to the Aqua Products case, the PTAB was putting the burden on the patent owner to show that their proposed claims included in their motion to amend were patentable over the prior art. That was, given the various constraints placed upon the patent owner, difficult to do. And while the Aqua Products case did say that that was not proper for the USPTO to put that burden on the patent owner, and as indicated in the Bosch case, petitioners may bear the burden of proving that the proposed amended claims are unpatentable by preponderance of the evidence. The reality is it's still very difficult to get these motions granted and to have your claims amended in an IPR or PGR proceeding. Likely one of the reasons for that is the PTAB is extremely busy, as many of you know. There's been a lot of use of these types of petitions at the PTAB, and the statute also requires the Patent Office to complete these proceedings within 1 year from the date of institution. So given all of that busy work that the PTAB is engaged in, for them to also go through handling a lot of motions to amend, where they're now also evaluating substitute claims or amended claims, that would significantly add to their task and potentially making it difficult for them to meet that 1 year deadline by statute. So as you can see from the graphic at the bottom, it's been difficult for challengers or for patent owners to get these motions to amend granted. At litigation, it is also not a great opportunity for a patent owner to amend their claims. The courts, they view themselves as not the Patent Office, and they recognize that there are other procedures as we went through and tools available for patent owners to go through at the Patent Office to correct their claims. So if you come to court with a patent that has errors or corrections that you want to make, the courts are often reluctant to fix or correct those errors. The basic rule is that courts will only correct errors if they are plainly evident on the face of the patent itself. As in the Overstock case, the error that the patent owner was trying to correct was to add in a limitation that was missing from one of the claims that was plainly evident from the prosecution history that for whatever reason that limitation was locked off and not included in the published claim, but the patent office is not, or the courts are not going to look into the prosecution history. It has to be of a very evident type of error that is seeking to be corrected, that's apparent on the face of the patent itself. You also need to be mindful of the fact that a certificate of correction only comes into effect once it is issued by the Patent Office. So, kind of following the maxim, if you will, that you need to dance with who you brought to the party. It's similar to you need to litigate the claims that were in effect when you filed the lawsuit. So, as in the Overstock case, where the patent owner sought to correct their claims through a certificate of correction during the litigation, that didn't save the claims from the issues that claim was facing, and therefore that claim was ended up being found to be indefinite by the court because the certificate of correction wasn't at issue or in effect during that lawsuit because it was filed after the lawsuit was filed. So let me kind of go through a few quickly kind of wrap-up points that we've kind of went through with respect to parallel litigations or parallel proceedings involving some of these tools that we were just talking about for correcting your patents. Let me try to do this in a few minutes here. And just to set the stage here, just a simple hypothetical where we have a competitor that we believe is copying our patented technology. Our negotiations have failed. We're now looking to improve the strength of our patents, because when we look at our patents, it doesn't have very solid claims with respect to distinguishing the prior art or capturing what the competitor is doing. And we might not even have a lot of backup positions because we only have perhaps, as in this hypothetical, 6 claims. What can we do? Well, as we were talking about before, you consider trying to strengthen your claims prior to enforcement or litigation. If you have a continuation pending, keep that continuation pending. That is likely a very good strategy for you, because a pending continuation can be just as effective as, for example, a reissue application, but where you can introduce new claims and that are better, stronger, and more targeted to the infringer. But at the same time, you're not dealing with the recapture rule, for example, because this is a regular patent continuation application. It's not a reissue application. If you file a reissue or reexam because you do not have a continuation pending, as we were talking about, you can use that as an opportunity to not only get stronger claims, but also add more backup positions to deal with potential invalidity challenges that might be coming down the line. And if you survive, if your patent survives this reissue or reexamination proceeding, the challenger may have a higher burden to invalidate your patent, because you now have gone through the second round of examination with more prior art, potentially any prior art that the challenger may likely be able to use during a challenge in the future. Well, what happens if the competitor beats us to the punch here and does file an IPR or PGR before we can fix our patents? Well, if we're involved in one of these IPR or PGR type of proceedings, we're going to have a very limited ability to amend. So one good option to consider is to file a parallel reissue or reexamination proceeding. Again, your allowance rate through reissue or reexamination statistically is much higher, 60% in a reissue or reexamination allowance rate, compared to, say, around 20-25% likely ability to have your claim survive in an IPR or PGR proceeding. That it's intuitive that you would have a higher chance of getting your claims allowed in a reissue or reexamination, because you're dealing with the examiner directly. It's ex parte. The challenger isn't there next to you arguing the other side to the examiner. Now, if you do file a parallel reissue or reexamination, the PTAB may stay or put on hold that reissue or reexamination proceeding while the IPR or PGR proceeding proceeds. But that IPR or PGR will only last 1 year. Afterwards, you may be able to have that stay lifted and to continue with your reissue or reexamination proceeding. And just as we've seen this in some of the cases we've been handling, if you file that reissue or reexamination before the PTAB issues its institution decision, you could help cause the PTAB to deny the institution, where they may look at the fact that there is another parallel reexamination reissue proceeding that's going to be handled. It's duplicative of the issues that are being raised by the challenger in the new petition, and perhaps that might have an impact or an influence on the PTAB denying the institution proceeding. What are some of the other issues to briefly consider? Again, given that there's a likelihood of the PTAB staying or putting on hold the reissue or reexamination proceeding, it may behoove you to at least think through of what types of claims you may want to pursue in that reissue. If one of the reasons why the PTAB would stay the reissue application, for example, is because there's an overlap of issues, and the PTAB wants to avoid inconsistent results when the same claims are being pursued in both the IPR, for instance, and in the reissue. But if you structured your reissue where you have different claims that are being pursued in the reissue, that may help avoid the stay, just to show that there's not the overlap. But you also need to be mindful, too, of Rule 42.73D3, which is that if you do have claims that are canceled in the IPR proceeding, then any claims that you pursue in the reissue have to be patently distinct from those canceled claims. And, of course, the issue with intervening rights, which I don't have the time to go into now, but that is certainly a factor when you're dealing with whether to amend your claims at all, given your desire to maintain your rights to collect damages and accuse of infringement at the activity by the competitor that has occurred before. And you don't want to necessarily lose those rights throughout your ability to do so through the concept of intervening rights. I'm not going to spend much time on this last slide here. This is my last slide, but it simply illustrates a timeline from another recent IPR proceeding where there was a parallel reissue that was filed. There was also a motion to amend that was filed by the patent owner that was denied. That reissue was then stayed, but then after the final written decision by the PTAB, the U.S. Patent Office did allow that reissue to proceed with the other claims that were basically in the reissue that the patent owner was trying to pursue in the motion to amend. But now they are able to do that in the reissue that they filed in parallel. So this kind of illustrates some of the concepts that we were discussing before with respect to filing a parallel reissue type of application. With that, if we do have time, we can turn it over to Anthony for questions, or we can certainly will get back to you via email because I know we did go over late. Anthony?
Yeah. Thank you, Tim, and thank you, Hazel. And yes, Tim, you are late. Let's try just quickly to sneak in a couple of questions. And as Tim mentioned, we'll try to answer the remaining questions by email. And of course, anyone can reach out to any of us if you have any questions following the seminar. Feel free to reach out to any of us via email. Quickly, Hazel, with regard to national post-grant amendment, can you give us a practical example of when you'd want it only in a few countries and not all of the countries?
Sure. I mean, I think there are a couple of obvious examples. One is that there can actually be different prior art in different countries sometimes. So you can have national prior rights that are only relevant in one country. So you may end up in a situation where you discover that you need to make an amendment in one country that you don't need to make anywhere else. So that's one example. And then you may just want to do it for commercial reasons. You may find that you have different infringers, different competitors in different countries. You may have different licensees in different countries, and so you may just have a different strategy in each country.
Okay, great. Thank you. Also for Hazel, in your opinion, does filing an auxiliary request after a positive opinion of the opposition division diminish your chance of success?
No, I don't think so. I mean, I think realistically an opposition division is only going to look at an auxiliary request if they've decided against an earlier request. I think it's a sensible thing to do to have auxiliary requests on file just in case, because you have a preliminary opinion that goes your way, that doesn't necessarily mean that that's what's going to happen on the day of the hearing.
Great. One last question. Tim, during a reissue or a reexam, are you still able to enforce your patent right, even though you're still stuck in one of those proceedings or one of those proceedings are still ongoing?
Your patent is still in effect even though there's a reissue or a reexamination proceeding in play, but you're also dealing with the prosecution history now that has potentially developed in either that reexamination or that reissue. So if your claims have been rejected, for instance, in the reexamination or reissue, that's going to be part of the public record that you're going to be dealing with. It's certainly more advantageous to do the reissue or reexamination in advance if you can, if time allows and the circumstances permit, to then complete that procedure, those proceedings, and then have a stronger patent at the end that you would then try to enforce.
Yeah, understood. Thank you, Tim. And everyone, thank you very much for attending today's webcast, post-grant amendments. As I mentioned, we'll try to answer some of the remaining questions directly via email, but please feel free to reach out to any of us via email, call, if you have any additional questions. Finally, I'd like to remind everyone, if you could, to take a moment to complete our evaluation survey. It's very helpful for us in terms of providing and continuing to provide programs of value to you and to improve those programs. So especially topics that you can provide which will guide us in planning future programs, we would really appreciate it. The presentation will be available on demand in the next week. Please look for an email from us with the access link. This concludes today's Finnegan webcast. Thank you again for participating, and everyone have a good evening. Take care.